Friends, today we are going to discuss a very important subject of criminal law which relates to law of rape. Rape as such is not only a crime against the person of a woman, that is victim, but it's a crime against the entire society. It destroys the entire psychology of a woman and pushed her into deep emotional crisis. It's only by her sheer willpower that she rehabilitates herself in the society which, on coming to know of the rape, looks down upon her in derision and contempt. The term rape is derived from the Latin term rapo, which means to seize. Thus, rape is forcible seizure, and thus that is the essential characteristic features of the offence. In common sense, rape means intercourse with a woman without her consent by force, fear or fraud. The objective of this provision is to prohibit and punish those men who have sexual intercourse against the will or consent of the woman. A non-consensual sexual intercourse is the crux of this offence. Though original provision was not so wide as it is today, interpretation of the provisions of situations leaving the victim primary suspect and a doubtful character, and therefore further victimization through trial, has led to amend the provisions of rape time and again. The prior position of the criminal law in India was very chaotic. The presidency towns living under the English criminal law were subject to a very artificial, complicated and foreign system, framed without the smallest reference to Indian and pronounced by a commission in England so defective that it could only be reformed by being entirely taken to pieces and reconstructed. Rape is not merely a physical assault, it is often destructive of the whole personality of the victim. A murderer destroys the physical body of the victim. A rapist degrades the very soul of the helpless woman. We have to remember that a rapist not only violates the victim's privacy and personal integrity, but inevitably causes serious psychological as well as physical harm in the process. The physical scar may heal up, but the mental scar will always remain. When a woman is ravished, what is inflicted is not merely physical injury, but the deep sense of some deathless shame. An accused cannot cling to a fossil formula and insist on corroborative evidence. Even if taken as a whole, the case spoken to by the victim strikes a judicial mind as probable. Judicial response to human rights cannot be blunted by the legal jugglery. Now the substituted provisions is defining rape, while the previous one was entirely on the basis of common law. But time and again it was tired to define the offence through judicial pronouncements. What are the meaning of some newly inserted phrases and words will be seen in the cases to come. This is too early to say anything on the appropriateness of this amended definition. In the mentioned circumstances, one new seventh circumstance inserted when she is unable to communicate consent, however, was being read by the courts in the earlier referred clauses against her will and without her consent. Every act done against her will also done without the consent, but vice versa does not necessarily so. This is important to use because there may be circumstances where the act may be done with consent but still may be against her will. There is a difference between submission and consent. Every consent involves a submission, but the converse does not follow, and a mere act of submission does not involve consent. Consent implies the exercise of a free and ultimate right to forbid or withhold what is being consented to. It always is a voluntary and conscientious acceptance of what is proposed to be done by another and concurred in by the former. Mere passive and helplessness, surrender of the body, and it is resignation to the other's lust induced by threats or fear cannot be equated with the desire or will, nor can furnish an answer by the mere fact that the sexual act was not in opposition to such desire or violation. A consent is not such a consent if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequences of such fear or misconception, or if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and consequences of that to which he gives his consent, or unless the contrary appears from the context if the consent is given by a person who is under 12 years of age. Clause 2nd to the 7th are just enumerating those circumstances where consent may be there, but because of the one vitiating factor inherited basically in those circumstances makes the consent not free consent, which requires conscious acceptance of the consequences. Here it is important to remember that section 19 of the Indian Penal Code, which states as to what does not amount to consent under the code. It says, if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequences of such fear or misconception of. By 2013 Criminal Law Amendment Act, rape has been defined in a very wide term. However, it is still not gender neutral, and section clearly says a man is said to commit rape, which means that this is only the man who can commit rape, not the woman. Despite the wordings used in the definition may make person of other gender also capable to do some acts other than penile vaginal penetration, or thereby it's not confined. Now, penis is not the only weapon by which rape can be committed. Similarly, vagina is not the only orifice which only makes the act rape. Society has rapidly changed, and penile vaginal is not the only form of sex. Oral, anus, and nearby parts of the vagina have become a subject of emerging trend of satisfaction of sexual urge. Explanation to section 375 in place of the previous explanation is more clear now, because the condition regarding which the previous explanation was reading out is included in the definition now, and as per the definition, penetration not only to vagina but to other parts like urethra, anus, and mouth is amounting as penetration, and it vaginal includes the labia majora, which is solving the question of depth or extent. Explanation 2 is very important, which is clarifying consent, because this was another problem to define and differentiate with will in the previous law. So this time this explanation says consent means an unequivocal voluntary agreement when the woman by words, gestures, or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. Unequivocal in its simple sense means admitting or no doubt or misunderstanding, having only one meaning or interpretation and leading to only one conclusion. So the meaning supplied here to consent is not quite different from what was perceived by the Supreme Court in the concerned interpretation. Section 376A is to meet the raising violence of long pending document on the society that rapists should be dealt severely, particularly in those cases where because of this commission of rape, victim's death is caused or she becomes living dead on vegetative state. It states that if in course of commission of an offence under subsection 1 or 2 of the section 376, such injury is inflicted which results into death or of the woman or causes the woman to be in a persistent vegetative state, rapists can be punished up to the death. But death penalty is not the only punishment here. Death punishment is to be inflicted only when the justice is not met by at least punishment of 20 years or imprisonment for rest of his natural life. Section 376B is punishing husband for sexual intercourse with his own wife without her consent when she is living separately because of a decree or otherwise is liable to be punished with imprisonment not less than 2 years but which may extend to 7 years and with fine. Section 376C, sexual intercourse by a person in authority who abuses such position or fiduciary relation to induce or seduce any woman either in his custody or under his charge or present in the premises to have sexual intercourse with him. Such sexual intercourse not amounting to the offence of rape is liable to be punished with imprisonment not less than 5 years but which may extend to 10 years and shall also be liable to fine. Section 376D, amending the provisions relating to gang rape. Where a woman is raped by one or more persons constituting a gang group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape. In matters of gang rape, it is not necessary that all should commit rape if more than one person who are there constituting that group with the common intention of committing rape, but some of them or any of them is not doing so, it shall be presumed that he has also committed rape. So what is necessary is common intention to do rape, not the actual commission. By the amendment, constituting a group is added in the previous existing provision of gang rape. So what is the meaning of constituting a group will be taken into be seen by the court's interpretations. However, under the previous provisions of gang rape, the Supreme Court in Bhupinder Sharma versus State of Himachal Pradesh case held that in case of gang rape, the proof of completed act of rape by each accused on the victim is not required. The statutory intention is introducing explanation 1 in relation to the gang rape appears to have been done with a view to effectively deal with growing means of gang rape. In such circumstances, it is not necessary that the prosecution should adduce clinching proof of a completed act of rape by each one of the accused or the victim or on each one of the victims, where there are more than one in order to find the accused guilty. Section 376E is punishment enhancing provision in case of those rapists who have repeated the offence of Section 376A and 376D. Such rapists shall be inflicted either imprisonment of person's rest of natural life or death. Now let's discuss something about what the courts have said, what's the judicial approach with regard to the rape law. Indian courts have taken the offence of rape very seriously. How the new provisions are interpreted, that is to be seen. But the court's approach in cases which have been decided under the previous provision relating to rape has been sensitive to women except in few cases. As appears from the court interpretation to the explanation of Section 375, which was making penetration essential to commit the offence of rape very liberally, that penetration need not to any extent or depth, mere friction or to labia majora may amount to penetration. This is what the new law is making clear, that vagina includes labia majora. Under the previous provisions, explanation was making it clear that penetration is sufficient to constitute the sexual intercourse necessary to the offence of rape. However, this was made clear by judicial interpretations that even penetration in labia major is penetration under this section, but the new definition is wide enough and including clearly to an extent into the vagina, mouth, urethra or anus of a woman, and this penetration need not be by penis only but by object or any part of the body, even by applying mouth or on vagina, urethra or anus is quite enough to prove penetration. In Sakshi versus Union of India, petitioner and NGO submitted before the apex court that the narrow understanding and application of rape under section 375 and 376 only to the penile vaginal penetration runs contrary to the existing contemporary understanding of rape as intended to humiliate, violate and degrade a woman, and this confined understanding denies a majority of women and children access to adequate redressal in violation of Article 14 and 21 of the Constitution of India, and therefore requested to widen the scope of rape by not confining it to the penile vaginal only, but other orifices and oral sex be included in definition of the rape. But the apex court said that the suggestions made by the petitioners will advance the cause of justice and are in the larger interest of society, and but declined to issue the writ in nature of direction to the Parliament to make law to meet the emerging needs, but hoped and trust that Parliament will give serious attention to the points highlighted by the petitioner and make and appropriate legislation with all the promptness which it deserves. In Tukaram versus State of Maharashtra, the Supreme Court acquitted two appellants of an offence of 376 read with section 34. In this case, accused police constables raped a girl of about 16 years when she went to the police station for lodging a FIR. In the given facts, the session judge found that there was no satisfactory evidence to prove that Mathura was below 16 years of age on the date of occurrence. He further held that she was a shocking liar whose testimony is riddled with falsehood and improbabilities, but he observed that the farthest one can into the believing her and the corroborative evidence would be the conclusion that while at the police station she had sexual intercourse and that in all probabilities this was with accused number 2. He added, however, that there was a word of difference between the sexual intercourse of rape and then rape has not been proved in spite of the fact that the defense version, which was a bare denial of the allegation of rape, could not be accepted and it is face value, and concluded that the prosecution had failed to prove its case against the appellants. The High Court took note of the various findings arrived at by the learned session judge and then itself proceeded to shift the evidence, bearing in mind the principle of reversal of acquittal would not be justified if the view taken by the trial court was reasonable possible, even though the High Court was inclined to take different view of the facts. It agreed with the learned session judge in respect of his finding with regard to the age of Mathura, but then held that deposition of the girl that Ganpat appellant had sexual intercourse with her was reliable, supported as it was by circumstantial evidence, especially that of the presence of stains of semen on the clothes of the girl and appellant. The fact that semen was found neither on the pubic hair nor on the vaginal smears taken from her person was considered to be of no consequences by reason of the circumstances that the girl was examined by the lady doctor about 20 hours after the event and of the probability that she had taken a bath in the meantime. The High Court remarked, I quote, "Besides the circumstances that emerged from the oral evidence on the record, we had to see what situation Mathura was at the material time. Both the accused were strangers to her. It is not the case of the defense that Mathura knew both the accused or any of them since before the time of occurrence. It is therefore indeed highly improbable that Mathura on her part would make any overtures or invite the accused to satisfy her sexual desire. Mere passive or helpless surrender of the body and its resignation to the other's lust induced by the threats or fear cannot be equated with the desire or will, nor can furnish an answer by the mere fact that the sexual act was not in opposition to such desire or violation, unquote. But the Supreme Court supported the view taken by the session judge, believing the facts that there was no marks of injury found on the person of the girl after the incident, and their absence goes a long way to indicate that the alleged intercourse was a peaceful affair, and that the story of a stiff resistance having been put up by the girl is all false. It is further clear that the averments on the part of the girl that she had been shouting loudly for help are also tissues of lies. Further, it held that Clause 3 of 375 speaks of it as negative by the circumstances that the girl is said to have taken away by gunpoint right from amongst her near and dear ones at a point of time when they were all leaving the police station together and were crossing the entrance gate to emerge out of it. The circumstantial evidence available, therefore, is not only capable of being constituted in a way different from the adopted by the High Court, but actually derogates in no uncertain measures from the interference drawn by it. The approach of the Supreme Court in this case was hugely criticized, and the hue and cry followed by the judgment put the pressure on the legislature to amend the law relating to rape under Section 376, Clause 2. And regarding consent under Section 114A of the Evidence Act, a presumption of law was inserted. In this case, the court was basically criticized for its being insensitive to such a crucial issue of the society, while on the other hand, this court was very much concerned even with the calling woman in the police station. In Nandini Satpathy, where this court, speaking through Justice Krishna Iyer, condemned the practice of calling women to the police station. In Nandini Satpathy's case, where this court, speaking through Justice Krishna Iyer, condemned the practice of calling women to the police station in gross violation of Section 161 of Section 1 of Code of Criminal Procedure. In this case, Supreme Court did not pay attention towards the facts that why she was asked to remain in police station even after her statement, while her relatives were asked to leave, and how it can be expected to a girl of illiterate and caught hold by two constables to shout and raise alarm. Now, friends, we have discussed law of rape, but one important issue which is involved with the law of rape is the punishment. There has been a demand from the people in general and the legal experts in particular that the punishment for rape should be death penalty. That is why newly inserted section by the 2013 Amendment Act, that is Section 376A, is just trying to meet the raising voice of death punishment, which has been time and again strengthened after the December 16 Delhi rape case. The courts have played a vital role to strengthen this demand that law related to rape occurred to be changed, however, left to the legislature to legislate upon. But whenever it got an opportunity, it signaled the protection of women against such a ghastly act in the utmost end of the time. Friends, with these words, we conclude today's discussion on the subject of rape.